Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3044, United States of America versus Ronnard Williams, appellant. Ms. Schnoor for the appellant, Mr. Andrews for the appellee.
Good morning, Ms. Schnoor.
Morning, Your Honors. May it please the court, Mary Schnoor representing defendant appellant Ronnard Williams. In denying Mr. Williams' suppression motion, the district court invented a novel and misguided exception to the Fourth Amendment, allowing a search of a vehicle's passenger compartment during any traffic stop where the vehicle's windows appear to be darkly tinted.
And you say it's any traffic stop, not just one where you're approaching and it's going to be tinted windows, and so you'd perhaps like to see in as the officer?
And any traffic stop where the vehicle's windows appear to be darkly tinted, Your Honor.
Okay,
Yes, that's correct.
So it is narrowed. It's not just any traffic stop.
Not any traffic stop.
Okay.
Any traffic stop where the vehicle's windows appear to be darkly tinted. At the time Mr. Williams was ordered to roll all of his windows all the way down, the officers who began the traffic stop had found him to be totally compliant, had done nothing to suggest that they feared for their safety, and indeed Sergeant Nisley testified that Mr. Williams had done nothing suspicious beyond the tint issue. The district court's decision runs contrary to Michigan versus Long, where the Supreme Court made clear that a protective search of a car's interior is permissible only if based on reasonable suspicion that the vehicle's occupant is armed or dangerous.
So Michigan versus Long, that was a different type of search. That was they went into the car. This is just visual inspection from the outside. And speaking of Michigan versus Long, under that case, couldn't they have done a protective search of this car based on reasonable suspicion that there was danger?
So it's true that in Michigan versus Long, the officers did go inside the car. However, that does not mean that this was not a search. And under Katz, there was a reasonable expectation of privacy in the interior of the car, as the Supreme Court has said in Class and reaffirmed in Byrd.
Yeah. Class was also a case where they went into the car. I think there is some support for the idea that you don't have a reasonable expectation of privacy of visual inspection into a car, because when a lot of these cases were decided, cars weren't tinted generally. It was like an unusual thing to have tint. And the general rule is if you can just see something, like you don't have a reasonable expectation of privacy in it. But it just seems to me that, do you agree that the officer could ask the driver to roll down the front window during a traffic stop?
We agree that the officer could ask the driver to roll down the window as necessary to facilitate communication and passing the license and registration.
But isn't it a really de minimis next step to roll down all the windows because all the windows are tinted? Because once you agree that one window can come down, the incremental difference between one and all seems pretty small.
I don't think so, Your Honor. I think there's a big difference between ordering all of the windows rolled all the way down and just ordering them to stay down so that the police can shine their flashlights in.
In legal terms, what test are you applying to suggest there's a big difference?
So I think it's the intrusion is greater into the privacy interest.
So you're not intruding any more than you would already be able to view if the windows were not illegally tinted.
I don't think that's correct, Your Honor. On this record, the district court did not make a finding. So DC law allows rear windows to be tinted up to 50%. And at night, 50% is quite a dark tint. I don't think the police would have been able to see the gun in plain view had the car's windows been legally tinted. And here, moreover—
But is that the standard we should be looking at, like what you can legally tint? I mean, that's just not a fact in this case. And you're assuming that everybody should have whatever protection they would have if their windows were 50% tinted. But what we have here is a different analysis. If you look at Mims and Maryland versus Wilson, which is you look at the government interest, which is the safety of the police officers, and you weigh that against the degree of intrusion, which is more minimal than what we had in Mims and in Maryland versus Wilson. So it seems to me that the district court just applied that framework, that analysis, and this case was easier than Maryland versus Williams or Mims because the intrusion was so minimal, because it's just rolling down 3 more windows when you could roll down 1. And the danger was greater because all of the cases that talk about danger in traffic stops, they don't involve tinted windows, which heightens the danger.
So I would disagree, Your Honor, with the idea that the intrusion in Mims and Wilson is greater than the intrusion here. I think it's a different type of intrusion. And so Mims and Wilson, that just concerns a seizure, and the incremental additional intrusion is just whether you're sitting in the car during a traffic stop versus being asked
But
to
that
step out of the
involves
car.
opening the car door, which gives you a view into the car, and then having people step out of the car. You think that is less intrusive than having people roll down additional windows when one is already rolled down?
I think so, Your Honor. So the brief, it's true that someone has to open the door to step out of the car, but they can do so briefly. They can shut it behind them. And here,
But when it's open, you can look into it.
that's true. That's true. But the police did not do that here. And the order here was to order all the windows down to expose the entire passenger compartment.
But I would like you to be careful about what you're asking for, because this is what comes to my mind. Unfortunately, there's a lot of issues with police and persons of color. You ask a person of color to get out of the car, but before they're taught to put their hands on the steering wheel, and then you ask them to get out of the car and you relieve their hands, and then they're trying to get out of the car. Potentially there could be a furtive movement just because they're nervous at that point, and then they could get out of the car, and then you don't know what else they're going to do. And I mention this because we had a case in South Carolina where the officer asked the gentleman at a gas station, go get your driver's license. That's what he did, and the officer shot him 5 times. And so I just would think you'd be a little careful about whether or not you want to push the law and be on the side of asking the person to get out, like that be the thing you request all the time. When you have the issue of somebody could be moving a little bit, the officer now has a heightened degree of safety. And that you're asking that to be the standard, that the officer should always ask the person to get out of the car, and then they could be moving and then cause another whole issue.
So I think it's true that traffic stops are always dangerous. They're dangerous for the officer. They may be very dangerous for the driver as well. There can be misunderstandings, and tragedy can result. But I don't think that that means that the police should always, whenever a window is darkly tinted, be allowed to order the windows rolled down. Now, if they had reasonable and articulable suspicion that an occupant of the car was dangerous, then of course, yes, they can search the passenger compartment. That's clear, and we don't dispute that.
So you're agreeing to let it just be lowered just enough to, what, hand over a license, or just to see the person?
Yes,
and questions?
That's sort of, so if you look at the facts of this case here, when the traffic stop began, Officer Laurie tapped on the window, Mr. Williams rolled his window down partially, and the traffic stop began, and he was, getting his license and registration. And it was not until the order to roll all the windows all the way down, including the back windows, that the officers were able to see inside and see the firearm. So that sort of supports that it was not possible for the police to see the gun here just because of that initial incremental window drop.
So when Officer Laurie tapped on the window, the driver just rolled down the window a little bit. I watched the video of this, and the car is completely darkly tinted, and they weren't asking to roll down the window so they could search for evidence. It was an officer safety issue. They don't know how many people are in the car. It's night. The windows are darkly tinted. They're illegally tinted, so you can't see inside them. And it seems to me that the district court just was addressing the officer safety issue. And Mims and Maryland versus Wilson support the idea that if you have a strong officer safety interest, reasonable suspicion isn't part of this analysis, because it's not reasonable suspicion to investigate the crime, to look for evidence. It's just to make sure the officers are safe. And it just seems to me that the logic of Mims and Maryland versus Wilson applies very cleanly here. And this is a lesser intrusion and a greater risk to the officer in this situation.
So I think in Maryland versus Wilson and in Mims, the court was only addressing the incremental intrusion on the driver's personal liberty interest from remaining in the car during the traffic stop to stepping out. And Mims and Wilson did not at all address the privacy interest in the interior of the car. And we think that interest is substantial. It's different than the interest at issue in Mims and Wilson. And so the district court did not, it's true that there is an officer safety justification, but you also have to look at the privacy side of the balance.
So why isn't this, another way of looking at this is during a Terry stop or a traffic stop, first of all, the officers are allowed to take complete control of the situation. That's in the case law. And also during such a stop, lots of things happen. Like Supreme Court has said, the officers could have a drug sniffing dog come sniff your car as long as it doesn't extend the stop. You can ask for license and registration. Obviously, you can have them step out of the car. You can ask about things that are unrelated to the traffic stop. Do you have any guns or drugs in this car? You can do all kinds of things. Why isn't, please roll down all your windows, just another thing you can do during a traffic stop?
I think because it is a search, and I'm not aware of any other case law holding that the police can do a search of.
Well, there's the
interior of
Texas
car.
versus Brown case that says you don't have a reasonable expectation of privacy in the passenger compartment of your car, or the visual inspection of the passenger compartment of your car, which means it wouldn't be a search.
You don't have a.
It's a plurality.
Yes. So if you can see something in plain view, you don't have a privacy interest in it, but the court has said you do have a reasonable expectation of privacy in the interior of your car to the extent something is not visible to the public. And given that.
So that kind of raises a whole different issue, which is interesting to me. It seems like a lot of these cases assume that you can look into a passenger compartment of the car. You know, they travel the streets. Everybody can look in and see who's driving usually, that kind of thing. And they kind of assume not tinted windows, like that passenger compartments of cars are normally visibly open, you know, to the outside world. And in that world, it would seem that there would be a strong argument that this is not a search because you have no expectation of privacy in a visual inspection of the inside of your car that you can see through your windows.
So we cite multiple cases in our brief where other courts, and also this court actually in Brown, treated opening the door of a car with darkly tinted windows as a search. And I think that's because you have a privacy interest in the interior of your car. And that's true.
Going in, right?
No. In Brown, the officer did not cross the plane of the vehicle. And that's true in Stanfield too. The officer did not lean into the vehicle, but.
And they upheld that. They said opening the door to look in was in Brown.
They said it was
upheld.
In Brown and in Stanfield, it was upheld, but it was upheld only after the court concluded that there was reasonable suspicion to support that search.
Well, Stanfield said that a bright line rule was appropriate and also did that other analysis. But I did ask you, do you think that a protective frisk of this car would have been appropriate?
In this case, on this record, no, I don't think there was reasonable suspicion to support a protective frisk of the car.
So just officers come up, they're not feeling safe. All the windows are dark. When they ask to converse with the driver, he only opens his window a crack. So I mean, Michigan versus Long, it seems like.
The record here is not that the officers did not feel safe. And to the contrary, Sergeant Nisley testified that Mr. Williams had done nothing suspicious beyond the tint issue.
It's an objective standard. So it doesn't matter if they subjectively felt safe or not, but
that's correct, Your Honor.
But a car, you don't know who is in it, how many people, whether there's a gun in there or not. All the windows are darkly tinted, and when you try to converse with the driver, he only opens the window a crack.
And then there was when the reasonable suspicion supposedly was created.
So it's true that it's an objective standard, but I would submit that the experienced officer's subjective understanding is pretty probative of what the objective, reasonable police officer would have observed or believed under the circumstances. And then moreover, as we argue in our reply brief, the government has.
But if there were reasonable suspicion, they could frisk that car.
If there were reasonable suspicion,
which
yes.
Means they could require them to get out, and then they could go into the car and look around.
Well, they could ask them to get out regardless, even without reasonable suspicion. But yes, we agree that if there were reasonable suspicion, they could order the windows rolled down and inspect the car and do a protective frisk. That's
Well,
correct.
I guess, are we ruling on that just requiring them to, when approaching a car because of the issue with respect to the dark tint, and you can't see, and that just having them roll down the window, that in and of itself is not the search. That's not the viably invasiveness into their privacy interests, that just rolling down the window? Or are you saying that it went a step further because then you're looking? I'm trying to figure out where you think the breach is.
We think the order to roll all the windows down was a search.
Okay, and why is that a search, just rolling down a window?
Because it is an
It just seems to me that there has to be some further activity.
So, Your Honor, we believe it's a search because it intrudes into a space where there is a reasonable expectation of privacy.
So would you be here if they had not looked in and saw the gun? Like you would just say, you can't do that?
If they hadn't seen the gun, then I don't believe there would be a motion to suppress. So no, I don't think we would be here.
No, but I'm just saying, I'm just trying to figure out that broader interest. Are you protecting against an officer not being able to ask that question, period, so that you never get to the next step? Or are you here just because they did get to the next step?
Just absent reasonable suspicion, we don't believe that the officer should be able to order the windows rolled down. And that's because there's a reasonable expectation of privacy. And given that—
At all, not even for the crack, to just hand over the driver's license and to see who's in the car, not even that?
Here, the order was to roll all the windows all the way down. And we're saying that's a search. If just the crack, no.
Okay.
That's correct.
If they only rolled it down a crack and then the officer said, roll it all the way down, would that be a violation?
Ordered just the driver's window rolled all the way down. I think that would be a different case. That's not what we have here, where it was to order.
I know that's a different case. That's a hypothetical. I
Were
just
the
asked
windows
you.
ever rolled all the way down?
Sorry, they were not, because the officers saw the gun before the rear windows had been rolled all the way down. I think.
But then that's what I'm getting at. I'm trying to figure out where you're thinking the breach is, because you're telling me asking to roll them all the way down is what you're here about, but yet they were never rolled all the way down. It was a crack, and that's when they saw it. So even at the crack, they saw it there.
Well, he was rolling down his rear windows only because he'd received that order. And I think, going back to your question, Judge Pan, I think that would be, I'm not sure that we would be arguing that if it was just the driver's window, that would be a search, because the driver's window, at least in DC, it would depend on the totality of the circumstances, but in DC, since the driver's window is not allowed to be as darkly tinted as the rear window, I think it's just a different analysis, but it would be under the totality of the circumstances.
I think the problem with your argument is you just don't grapple with officer safety at all. Like you're talking past what the government and the district court did, because they were focused on officer safety. Officers can take reasonable steps to make sure that they're safe. And you're focused only on the acquisition of evidence or the investigation of crime, which is what reasonable articulable suspicion addresses.
No, I think, Your Honor, we take the officer safety justification very seriously, and I don't want to minimize the officer.
Then how does that come into your analysis?
So I guess on the officer safety side of the equation, if this court were to endorse the district court's rule, it would make a difference only in those cases where there's no reasonable and articulable suspicion.
No, I'm just saying if we adopt your rule doesn't consider officer safety at all.
Well, it does in the sense that under Mims and under Wilson and under Long, police have tried and true options for protecting themselves during a traffic stop. And so we're just saying—
That doesn't include rolling down windows.
It includes rolling down the windows if there's a reasonable suspicion, which is, again, a low bar, as the government says in their brief.
I'll just try to put this more clearly. Your rule says we should always look to reasonable articulable suspicion, that is the lodestar. And that takes no account of officer safety.
So we are arguing that under Long, reasonable suspicion is required. But even if you disagree with that, and you think there should be a balancing of the interests of the public safety interest versus the privacy interest.
But you agree that your analysis takes no account of officer safety?
We think that the privacy interest outweighs the public safety interest in this narrow case.
But that's not a reasonable articulable suspicion standard, just to be clear.
That would be if you yeah, we agree, or we believe that reasonable suspicion should be required, but even if you disagree with that, we think that and we think that the privacy interest outweighs the public safety.
But a partial roll down, when you've been asked to roll down, why isn't that then lead itself to reasonable suspicion that, okay, you only took it halfway down?
Well, he was complying with I think the question is whether the order here was a search or not. And he was complying with the order, and it's true that the police saw the gun before the window was rolled all the way down.
Okay, so then why isn't, but that goes back to earlier, I think you said rolling it down a little bit was okay.
I think what I said was that when there's a traffic stop, we acknowledge that the driver's window would need to be rolled down partially to facilitate communication and passing of the license and
And
registration.
when it was rolled down partially, they saw the gun.
No, Your Honor, the driver's window,
Mhm.
I was talking about the driver's window before,
Okay.
but what allowed the gun to be seen was the rear window being
Okay.
rolled down.
And if they had seen the gun through the partial roll down of a driver's window that was open on the command of the police, is that a different case?
Yes, I think then that would be plain view.
Okay.
If the court has no further questions, we'd ask that the denial of Mr. Williams' suppression motion be reversed.
Thank you. We'll hear from Mr. Andrews.
Good morning, and may it please the court. Peter Andrews for the United States. The officer's order here to roll down the blacked out, illegally tinted windows of Mr. Williams' car was a reasonable safety precaution that did not violate the Fourth Amendment. As this court has discussed with my colleague, traffic stops are dangerous, and the case is established that police officers are allowed to take reasonable safety precautions and need to take command of the situation when there's a
Okay, so
traffic
the
stop.
driver rolls down the window partially. Police don't see anything at that time. Driver has submitted to your command, so then why go further? Because at that time, at least there's no testimony about officer safety.
Your Honor, the police officers in that instance are not able to see anything in the car other than what they can see through the crack in the driver's side.
And it's the driver who you're after, because the driver is driving the tinted car.
But the police officer, I think, does not know whether there is anyone in the back seat. It turns out, of course, and this is why this is important. It turns out there is a person in the back seat who they're not aware of, and that person has a loaded gun at their feet.
Mhm.
And so the police officer.
But we're trying to get at what you should do immediately, not what it turns out to be, and then back into the story.
Yeah, the video makes clear this all does happen very fast. And I think when the officer approached the windows rolled down just a crack. I think a reasonable way of looking at the video is he is not sure what's in that car, right? All you can see is apologies. All you can see is the little crack of Mr. Williams's face. He's rolled down the window just a tiny bit, and otherwise the side windows are completely blacked out.
Sunroof was open, right?
I'm not sure about the sunroof. I can't see into the sunroof of a car when I'm just standing there. I don't think the officers could. So the officers in that situation are faced with the question of how to take control of the situation. And it's reasonable under the Fourth Amendment to order the windows rolled down so they can see what's in the car. The analysis here is exactly what the Supreme Court proved in Mims, where we are balancing the danger to the officers against the privacy interest. The danger to the officers is apparent in traffic stops. Both the officers and Judge Child's question about people of color earlier, I think it's dangerous to civilians too when police officers don't know what's in the car. Civilians don't know how police officers are going to react to them. So there is a serious danger issue when approaching a blacked out tinted window car.
Can I ask you about that? Are you aware of statistical evidence that the ratios of fatal police shootings per arrests or stops differs between racial groups?
I am not aware of any statistical evidence on that point about racial groups, Your Honor. What we're relying on for the dangerousness of traffic stops is the statistics that are cited in cases from this circuit and from cases like Stanfield that talk about the danger of traffic stops generally. As to racial groups, I was specifically trying to acknowledge Judge Child's question, but I don't have any statistical evidence about different impact on racial groups.
So from the Department of Justice's perspective, you do not have the impression that ratios of fatal police shootings per arrests or stops differs between racial groups.
I don't have statistics on that either way, Judge Walker.
How should we think about the degree of the tint on the car? It seems to me in this case, it's a little easier. It's a legally tinted, very dark car. What if it was just a legal amount of tint, but the officers still couldn't see? Could they still order the windows to go down?
That is a more difficult question. I think you're right. I think the threshold question is, do the officers have probable cause in that circumstance to begin a window tint stop? So the officers have a, in that circumstance, if the officers
What if they're stopping them for a different reason? It's the parking violation in this case too.
So if it's a situation where the officers can't see into the car, then there is a very elevated safety interest. There may be a greater privacy interest because if a person is compliant with DC's regulations about how to see into the car, there is a stronger argument that they have a reasonable expectation of privacy in the car.
What if there's no tint on the car, but there's a glare, so they can't see in the car because there's something shining off the window? Can they make them lower the windows?
So I think glare is a more difficult question because I think the police can take steps to mitigate glare. I do think that this is a fact-intensive question. Mr. Williams has kind of framed this as the district court has adopted a bright line. We don't read it as a bright line rule, and this court doesn't need to.
Shouldn't your position be that police officers can take reasonable steps to protect their safety? And if they can't see in the window, whether it's because it's minimally tinted, but it's dark, or there's a glare, they should be allowed to do that?
I think that is right, Your Honor. The officers need to take steps to protect their safety in circumstances where, in the automobile context, drivers have a lessened reasonable expectation of privacy in the visible passenger interior of their car. So in almost every circumstance, when you weigh the officer's safety interest versus the privacy interest, it's going to come out in favor of the officers.
And I had earlier asked your opposing counsel about essentially how far do we take this? Is this a window tint case, or is this for any police traffic stop that you could allow a person to roll down their windows?
So I think Judge Pan articulated it well. It's a situation in which the police are unable to see what's in the passenger compartment, where they're unable to determine whether or not who's in the car and whether or not who's in the car presents a danger to them. Because that's specifically what we're focusing on here is, do these people exist at all? And do they present any danger to?
But we could decide that question as a bright line rule, like in Mims and in Maryland versus Wilson, or we can just say, under the circumstances of this case, it was reasonable for them to order the windows to go down. So should we do a bright line rule like in Mims and Wilson, or should we just say, oh, in the facts of a case like this, that was reasonable?
So we've, in our brief, argued that you can rule on this simply as under the facts of the case, this is reasonable. I think a bright line rule would look very similar to a rule that in most reasonable circumstances, when police approach a car, that they are allowed to order the windows rolled down. So I don't think there's anything inconsistent with adopting a bright line rule. As the Fourth Circuit was talking about in Stanfield, the Fourth Circuit absolutely reached the conclusion that a bright line rule would be appropriate. But you can also write an opinion that says, under these circumstances, it was a reasonable safety precaution.
So the reasons, bright line rules are generally disfavored, but the reasons to do a bright line rule is they provide certainty for police officers engaged in the competitive enterprise of ferreting out crime, so that they know that I can do this without thinking about it, overthinking it in the moment. And is that a factor that weighs in favor of a bright line rule in this situation?
Certainly from a law enforcement perspective, more clarity about what law enforcement can do in any situation is welcomed. But as you indicate, there's also case law illustrating or indicating that bright line rules are generally disfavored. So either of those rulings are consistent with the logic that we've put forward in our brief and that we think is supported by the Supreme Court's case law in this area.
One of our cases mentions that every year 6,000 officers are assaulted during car stops. Should that be a factor in whether we do a bright line rule or whether we do this as a case by case, make the officers think hard about it and double check twice, dot their I's, T's?
Well, certainly the officer safety interest in these cases is very significant, as these cases indicate. And so a bright line rule does have benefits in terms of allowing officers to understand very clearly when they approach a car what they are and are not allowed to do.
Was this a search? I mean, I know once they reached into the car, but the order to roll down the windows, was that a search?
No.
And what's your argument for that?
So it's not a search for a few reasons. One is that, as we've talked about, MIMS and its progeny talk about these kinds of protective measures as interactions with a person's privacy that don't require reasonable suspicion, like a search typically does. But beyond that.
But the definition of a search is an invasion of a reasonable expectation of
Right.
privacy. So for this not to be a search, you would have to say there is no reasonable expectation of privacy.
So it's
in the
not.
passenger compartment of the car for a visual inspection.
That's right, Judge Pan. But so our position is not that there's no reasonable expectation of privacy, but there is a substantially lessened reasonable expectation of privacy in the passenger compartment of the car. The cases.
Is there a case that says if there's a lesser interest, there's no search? I thought you had to have no reasonable expectation of privacy for there to be no search.
So if you look at class, my reading of class is that class does not, ultimately they bless the search in class without they call it a search, but then they say reasonable suspicion wasn't required because the VIN is required to be in a place that's in public view and because of the lessened reasonable expectation of privacy in the VIN because of its placement within the passenger compartment. So the way to think about this is in the safety precautions context, we're balancing officer safety with expectation of privacy. There's a substantially lessened expectation of privacy in the interior of a car because it's supposed to be something that
But class said that there is an expectation of privacy in the interior of the car, but under the facts of that case, because the VIN was obscured and it's intended to be visible from the outside, it was okay for the police officers to go in and move some papers to unobscure the VIN. That's very different, but they did say that there is an expectation of privacy in the passenger compartment of the car.
there is some expectation of privacy, is how to read class and its progeny and cases like Texas v. Brown that says.
And if there is some expectation of privacy, it's a search.
So I would say it's not a search because we're in reasonable safety precaution land, but if it is a search because we're in reasonable safety
That's
precaution
just
land,
a
it doesn't.
different analytical framework.
Sure.
Whether something is a search is different from this balancing test that's in.
So Judge Pan, whether it's a search or not, our position is that reasonable suspicion is not required to.
Got that.
Got it. If there are any further questions, we'd ask that Mr. Williams' conviction and sentence be affirmed. Thank you.
Thank you. Ms. Schnorr will do 2 minutes of rebuttal.
Thank you, Your Honor. First, going to Judge Pan, your question to the government, I would like to emphasize that the rule here affects the privacy interests of people who are driving legally tinted cars. The government has just confirmed that. And that's because the search would be allowed so long as the officer was not believed that the windows were darkly tinted and was having difficulty seeing in. And that could very well be the case with legally tinted
So my
windows.
question on that though is, does it matter whether it's legal or illegally tinted if the officer can't see? Because if the interest that we're trying to promote or protect here is officer safety, if they can't see, they can't see. It doesn't matter if this is a legal tint or a legal tint. It's dark, they can't see. They should they not be allowed to lower the windows?
I think you're right that the officer safety interest is is the same there. As you said, if they can't see in, they can't see in. But the point is that this is not just about people who are violating the window tint regulations. It's also about people whose cars are perfectly legal, who have a reasonable expectation in their rear seat being somewhat shielded from public view. Not entirely, but maybe enough for them to feel comfortable, for example, changing clothes, breastfeeding a baby, carrying something that they might not want exposed to public view. And so this rule would allow the police, regardless of any suspicion, to order them to roll all those windows down. Second, going to Judge Childs, your question about the partial roll down, I would just like to note that courts have recognized that merely withholding consent to a search does not create reasonable suspicion. We cite cases at page 20 to 21 of our brief. So to the extent Mr. Williams rolled his window down partially and not entirely, that would not create reasonable suspicion. And I would also note that in the record here, the police could see through the untinted windshield and through the sunroof. And so the record is that Sergeant Nisley could see that there was a passenger in the back seat before the windows were rolled down. So it wasn't that it was entirely impossible for them to see inside the car.
If the officers had ordered everyone out of the car, that would have been legal, correct?
Yes, Your Honor.
So if you can order everyone out of the car, why can't you order the windows to be rolled down when, number one, it seems less invasive to roll down your windows as opposed to come out of the car, and number two, to Judge Child's question, it seems safer, both to the officers and to the passengers.
Excuse me, sorry. So we think it's differently invasive, again, because
You think it's more invasive?
I think it's just different interests. As
but
the
it's-
Ninth Circuit said in New Mezi,
I get that it's different, but something can be different because it's less invasive and something can be different because it's more invasive. And I suppose something can be different in an equally invasive way. But which of those do you think it is?
I think it really probably depends on the precise circumstances and, you know, for someone who might have difficulty getting out of the car, like an elderly person who was having difficulty moving, it might be more invasive to ask them to step out of the car. But if you have something in the back seat that that you don't want everyone on the street to see, it might be more invasive to have the windows rolled down than to simply step out of the car. So I think it really depends on the circumstances, and they're just different interests. It's a liberty interest versus a privacy interest.
I'm thinking about your backseat example. I mean, would it, under MIMS, can you order someone to get out of the car and leave their door open after they get out?
I don't believe a court has held that. I think if someone chose to leave the door open, then there would still
I mean,
be
at
plain
that point,
view,
they
but
get
no,
out
I
of the
don't.
car, they're being detained. It's not a full arrest, I get that, but they're being detained. So it seems a little odd to say that while you're being detained, you're free to close your car door if you want to.
I think you are free to close the car door because MIMS didn't.
So.
Yeah, just MIMS is only about asking someone to step out.
Okay.
So yeah, so police cannot search the car just because they can order someone out of the car.
Maybe so. Thanks for helping me think through the questions. I know I took up some of your rebuttal. If you want to take another 10 or 15 seconds.
Well, I would just, to sum up, allowing discretionary searches of a vehicle's passenger compartment during any traffic stop where a vehicle's windows appear to be darkly tinted would inappropriately extend MIMS and intrude substantially on individual privacy interests. So we would therefore ask this court to reverse the denial of Mr. Williams' suppression motion.
Case number 23-5232. Dog Society and International Documentary Association, Appellants versus Antony J. Blinken, Secretary United States of Department of State, and Alejandro N. Mayorkas in his official capacity as Acting Secretary of Homeland Security. Ms. DeSalle for the appellants, Mr. Brewer for the appellees.
Ms. DeSalle, you may proceed.
Thank you, Your Honor, and may it please the court. My name is Caroline DeFell, and I represent the plaintiffs' appellants. I'd like to reserve 2 minutes for rebuttal. This case concerns government regulations that burden the free expression and association of millions of people each year, all while adding no demonstrated value to achieving the government's stated aims. Normally, courts wouldn't hesitate to conclude that these kinds of regulations are arbitrary and capricious under the APA, and poorly tailored under the First Amendment. Because these regulations relate to immigration, however, the district court concluded that they were effectively off limits to judicial review. The government now doubles down on that conclusion, asking this court to hold that meaningful review of any government action that touches on immigration is foreclosed.
I'd like to direct you toward the standing question. And a lot of the briefing is about injury, and maybe we can talk about that a little bit later. But I have a bigger concern about causation and redressability after Murphy.
Yes,
And so I'll just share kind of what I'm thinking, and then you can tell me where I kind of went off the rails. But state officials, even before this rule, State Department officials could already demand social media profiles on an ad hoc basis. Is that correct?
Yes, Your Honor, they could.
Okay. So in this case, the rule requires revealing those social media profiles. So the previous kind of status quo where they could demand the profiles, that is unchallenged conduct. But the new rule is challenged conduct. So far, so good.
Yes, Your Honor.
And then there's allegedly some self-censorship because people say, I don't want the State Department, if I apply for a visa, to see what I was doing on social media. It's hard for me to know whether that self-censorship is caused by the unchallenged conduct or the challenged conduct, because you could imagine either of them chilling speech and causing self-censorship. And there it seems very like Murphy, because in Murphy, the social media companies had their own policies, and that was unchallenged conduct. There was allegedly government pressure on the social media companies, that was challenged conduct. And there was self-censorship. And the court said, well, we can't know whether the self-censorship was caused by the unchallenged conduct or the challenged conduct. So this really does seem quite analogous to Murphy.
So thank you for the question, Your Honor. I think I have 2 key responses. First, there's a big difference between the mere possibility that in the context of an individual visa application, an applicant might be required to provide additional information to aid the consular officer's decision there, and the absolute guarantee under this dragnet disclosure requirement that you will be forced to disclose 5 years worth of social media handles that exposes many more years of social media activity to the government to then be retained in government files for 100 years after your birth and put to any number of unknown uses in the future. So the chilling effect, we think, is much more pronounced and universally suffered in this case by visa applicants. The second point I would raise is simply the specificity in the allegations in our complaint. We have identified a number of different plaintiffs, members, and partners who have said that it is specifically because of the disclosure requirement that we're challenging in this case that they have ceased to speak on social media in anticipation of applying for a new or renewed visa, for example. And so the specificity of the allegations in this complaint differs starkly from what the court reviewed in Murphy.
I'm not sure. The instances in Murphy involved individuals whose names were given, the specific content that they wanted to post, the specific kind of censorship by the social media companies that had come down on them. Sometimes it was kind of, I forget all the terms, but sometimes it was just blocking them, but sometimes it was making it harder for people to view them. Here, your most specific person is some guy in the Midwest. We have no idea who he is. We don't even know what state he lives in. It's just the Midwest. And we don't know if he's eligible for a visa. We don't know if he's planning to apply for a visa tomorrow or next year. This sort of has a Lujan flavor to it of like maybe sometime down the road he'll apply for a visa. Actually, I say he, and I think it's a he, but I don't remember if you even gave us the person's gender. Is it a he?
We did not disclose in the
Did not
complaint
give
for
the
reasons
gender
that I
either.
can get
I mean,
into.
and I get that, your whole case is they're worried, so you can't give me, name, rank, and serial number. I get that, but some guy in the Midwest who might one day apply for a visa is pretty non-specific.
So thank you, Your Honor. With regard to the specificity, the contrast that I was drawing between our complaint and the Murphy complaint, what I'm really focusing on is the specificity with regard to the challenged government action. That's what Justice Barrett and the Murphy decision found lacking in that case, a tight connection between the challenged government action and the censorship that the individuals claim to have suffered. But moreover, in that case, the court made clear that the burden on plaintiffs increases throughout stages of the litigation. There was a dense evidentiary record in support of a preliminary injunction motion. Whereas here, this case is before the court on a motion to dismiss. And we think that the complaint identifies plausible allegations with the requisite specificity to survive a motion to dismiss. But moving forward in the case, there are a number of tools at the court's disposal to allow for protection of the identities of the members and partners who were quite concerned about disclosing their identities to the government, in part because some of them are challenging the forced disclosure of pseudonymous social media handles. So to identify themselves in the context of a challenge to the government would defeat the purpose of the challenge.
If I could
But-
follow up on
Yes.
Judge Walker's question, focusing on redressability.
Yes, Your Honor.
You do have evidence that people stopped using social media because of this rule, but there isn't evidence that they would start using it again if the rule were vacated. And it seems to me that if there's still a risk that they can be asked about their social media activity by the consular officer in an interview, it has the same chilling effect. So how does vacature of this rule redress that chilling effect?
Thank you, Your Honor. Again, in speaking to plaintiffs' members and partners, it was really the forced upfront disclosure of this information that resulted in the chill that they alleged in the complaint. But I would point the court to two cases that I think are instructive here. One is Department of Commerce versus New York that the court in Murphy cited in an extensive footnote, and another is Americans for Prosperity Foundation versus Bonta, where the Supreme Court concluded that a government disclosure requirement at the outset has what it termed basically an inevitable chilling effect on speech and association. And that the invalidation, in that case, the facial invalidation of that disclosure requirement would be sufficient relief to the plaintiff organizations and their members in that case.
But in the facts of this case, though, there's the continued chilling effect of the fact that the consular officer can still ask you the exact same question.
Yes, and I think that actually was probably the case in Americans for Prosperity versus Bonta as well. The court acknowledged that the state of California could conduct its own investigations into the propriety of the charitable organization's relationships with its donors. But in any event,
Seems a little
here,
bit more direct, though, because if you apply for a visa, you have to have that interview. So it's not just kind of, will the government focus on me in an investigation, which is a lot more amorphous. Whereas here, there's always going to be individual scrutiny of each applicant. And the question is just, this particular question, can it be asked in a dragnet fashion, as you say, or it can always be asked on an individual basis? And from the perspective of somebody who's applying, I feel like you're chilled either way.
I respectfully disagree, Your Honor. I think that the absolute guarantee that you will be forced to disclose your social media handles to the government upfront in the application process stands in stark contrast to the mere possibility that a consular officer who's quite busy with a number of different adjudications will demand that information in your case, particularly given that it might very well not be at all relevant to the adjudication of your visa there.
So shouldn't you have had evidence, affidavit, something of somebody saying that if you vacate this rule, I will start speaking on social media again?
We would be happy to provide that evidence going forward, Your Honor.
Little late for that,
Again,
isn't it?
subject to appropriate protective orders, et cetera. We would love the opportunity to allow this case to proceed further in the litigation.
Assuming that that's not an option, that you just get a second bite at the apple at proving standing, already had a chance.
One other thing I would note is that we did request to the district court the opportunity to amend our complaint if the district court considered it insufficiently specific to substantiate our standing. But the district court concluded that that would have been futile because the court concluded that the disclosure requirement at issue here is not subject to any review whatsoever under the APA and subject only to the most deferential review under the First Amendment.
But you don't specifically state in your complaint that if the policy were ceased, that people would, go back into social media, with their partners, members, et cetera, and seek that information.
Your Honor, we don't specifically state that, but I think that's a reasonable inference from the allegations we do make in the complaint, which include numerous statements that it is specifically because of this disclosure requirement that plaintiffs, members, and partners have stopped speaking on social media. And I'd like to take this opportunity, if I may, to emphasize that plaintiffs have three separate theories of standing in this case. One is based on the informational injury that the district court concluded sufficed for standing here, which really ties to the chilling effect on plaintiffs, members, and partners on social media. We do have two other separate theories of standing. Another is
Before you get to those, though,
Yes.
let's talk about, because it is dealing with informational injury.
Mhm.
How do we square the Supreme Court case, Akins and Alliance for Hippocratic Medicine with PETA, for our district? Because you have one, at least at the Supreme Court level, suggesting that there's a legal requirement to the information versus you rely on the information, which is what our cases are talking about. And I'm just trying to square those two together.
Thank you, Your Honor. Yes, the cases that were referenced in the FDA versus Alliance for Hippocratic Medicine decision are cases in which the plaintiff organizations are seeking information from the government specifically. And so in those cases, the court is concerned about the concreteness and particularity of the injury alleged by plaintiffs. And so the court has required plaintiffs to show a statutory right in some instances to the information sought. Here, in contrast, I would argue that our case is much more aligned with Havens Realty Corporation and another case out of this circuit, Action Alliance for Senior Citizens of Greater Philadelphia versus
But I guess what
Heckler.
I'm asking is, are those cases in conflict, our precedent with the Supreme Court?
No, Your Honor. They're consistent with the Supreme Court's decision in Havens Realty Corporation, which the court and FDA acknowledged, was still good law. And in that case, the plaintiff organization suffered an injury to its pre-existing mission critical activities, which were counseling home seekers. And it was the challenged action by an apartment complex there that had really kind of polluted the flow of information to the organization. And that gave rise to a sufficiently concrete and particularized injury to support standing.
So you're only suggesting that you just have to show that you rely on the information. You don't have to have a legal right to it.
That's right, Your Honor. We believe that the government
There was
interruption.
a legal right to it, Havens.
So the plaintiffs in that case argued that the information that the apartment complex had provided was counter to law, so that the apartment complex had engaged in racial steering. We're arguing that the government here is violating the APA and the First Amendment in requiring the disclosure of social media handles, and that has very specifically disrupted the flow of information from plaintiffs' members and partners.
In your case, the information in question is information that a third party can choose to post or could choose to not post, right?
Yes, Your Honor.
And in Havens, the information was information that Havens was legally required to state truthfully, correct?
They had to state it truthfully, yes. I
Yes.
mean,
So
to the extent they
in
were
Havens,
requested.
and you don't have to take my word for it. We said it, Hippocratic Medicine has said it, but in Havens, there is a legal right to the information. The plaintiffs had a legal right to the information in question.
To non-lies,
A
yes.
statutory right, yeah, to non-lies, to non-racist lies.
Yes.
And here, the plaintiffs do not have a legal right to the posts of third-party social media users, correct?
Well, what we're arguing is that they have a legal right to receive information that those users would have been providing, but for.
What statute gives you a right to the person of an unknown gender in the Midwest and his posts or her posts on social media. Let's call this person John Doe. What statute gives your clients a legal right to John Doe's Facebook, to John Doe choosing to make Facebook posts?
So again, I would say I can see that there's no legal right to have this information provided to the plaintiff organizations, but there is a legal right not to have the government disrupt the flow of information, as we've alleged under the First Amendment and the APA here. And then I would also point the court to the Action Alliance of Senior Citizens of Greater Philadelphia versus Heckler case, where the issue there was the Action Alliance had challenged HHS regulations that in some instances had required the beneficiaries of federal funding to provide certain information to HHS for approval of that funding. And then with respect to HHS specifically, so that was a government-wide regulation, with respect to HHS specifically, it stopped requiring those private parties, the recipients of federal funding, to provide the same information. Action Alliance didn't allege any pre-existing legal right to information about the ages of people receiving services from those funded organizations. But nonetheless, the court concluded that they had standing to challenge the difference in those regulations that HHS had promulgated.
I take that point, and your opposing counsel can respond on that case if they wish. I want to follow up on your statement that, well, let me just read you something that Hippocratic Medicine said. Oh, I know. Your statement that there's a difference between a case where you're seeking information the government provides, and that's your informational right, versus here where you're seeking information that a third party provides, and that's your informational right. It seems like that might cut against you, because there, in both cases, I guess you'd sue the government, but when it's the government's information, that's a more direct injury to you. Here, it's a more indirect injury to you because you're suing the government, but it's not even the government's information.
I think perhaps this question gets to Judge Pan's question about kind of traceability and redressability. And there, what I would say is that the standard, first of all, is whether or not the injury is likely traceable to the government's action. Again, here we have very specific allegations that it is because of the government's action that plaintiffs have been chilled. And again, I would point to Americans for Prosperity versus Bonta and the Department of Commerce case as supporting the likelihood that the government action caused the injury, even though third parties or the more kind of immediate actor in that situation.
And then I do think that you are correct that at least until recent Supreme Court cases, in the DC Circuit, you could get standing through an informational injury, even if you didn't have a statutory right to the information. That PETA says that. But after PETA comes, among other cases, Hippocratic Medicine. And Hippocratic Medicine says the associations have not claimed an informational injury, and in any event, the associations have not suggested that federal law requires FDA to disseminate such information upon request by members of the public. I just can't imagine why that line would have been in the opinion if the court didn't believe that in order to assert an informational injury, you need federal law to require the dissemination of that information to the plaintiffs.
So, Your Honor, again, in that case, the plaintiff organizations were alleged, I think actually it was the government on behalf of the plaintiffs, were alleging an informational injury because, I'm sorry, I'm confusing that with a different case. Quite the opposite, yes.
There's a lot of cases. And
I apologize.
They don't all match up.
But there, the plaintiff organizations were alleging that they suffered an injury because FDA was no longer providing the same kind of information that they previously had. So again, the organizations were claiming an injury stemming from lack of information from the government. And we, again, contrast that here. So putting aside the point that in the court's own terms, that paragraph is effectively dicta, we think that's a different line of cases where the plaintiffs are requesting government information. And the concern in these cases is really whether or not there's a sufficiently particularized injury, as the court has held plaintiff organizations or plaintiffs in general need a personal stake in the litigation. And here we've explained at great length in our complaint the personal stake that these organizations have in receiving this kind of information from their members and partners on social media.
I get that the information is useful, maybe very important to the plaintiffs. I think they don't have a federal right to it. Let me also ask about this line from same case, Hippocratic Medicine. It says, according to the medical associations, FDA has impaired their ability to provide services and achieve their organizational missions. Sounds a lot like your theory. And then the next line is, that argument does not work to demonstrate standing. So what are you asserting for standing that goes beyond the government has impaired your ability to provide services and achieve your organizational missions?
Within the context of our informational injury argument, and I want to emphasize again that we have another organizational standing theory relying on constitutional injuries. And in addition to that, plaintiff IDA has associational standing based on the injuries suffered by its particular members. But staying within the context of the informational injury theory, here, the allegations that those organizations were putting forward were much more amorphous than the allegations here. For example, Doc Society hosts what it calls the Doc Impact High Five Awards that are supposed to celebrate documentary films in part for their social impact. And Doc Society specifically measures social impact by looking at social media engagement, among other things. That relies crucially on information that its members and partners from around the world are providing on social media. And IDA has discovered cases of filmmaker censorship in countries around the world and then gone to great pains to investigate those cases, provide resources to those filmmakers, develop programming at its Getting Real conferences in the United States, tethered to the information that its filmmakers are providing, again, on social media, that enable it to provide the services that they provide to its broader community.
Can you give us a concrete example of speech that was chilled because of this rule and how you would have used that speech?
Yes, we've identified a number of individuals who say that because of the disclosure requirement, they have stopped speaking on social media or have gone back and reviewed
I'm just trying to understand what is the injury to your clients, because I see a lot of evidence that they're chilled. But then how would you have used the speech that they have just decided not to make?
Yes, Your Honor. So the speech, let me just point you to a few paragraphs in our complaint.
Actually, it's not in the complaint. I want a concrete example. For example, John Doe, he normally would say, I don't know, I support Donald Trump. And now he's not saying it. How would you have used that? I'd want an actual concrete example of how this works. Like, how does your organization use the speech that is chilled?
So, for example, there are people, I'll go back to the filmmaker censorship cases. The members, I think it was IDA members in that instance, who are providing information about being chilled in countries where they're working, being censored by governments in countries where they're working. That
They would normally have said that on social media. I'm being censored. Like, I'm just trying to,
yes,
please, concrete example.
Yes, they have said that on social
Okay.
media, and
They're being
IDA has
chilled
been
by
investigating.
foreign countries?
Yes, so they're being.
That means they're not being chilled by our country.
Sorry, let me connect the dots here. So in those cases, there are filmmakers in other countries who are facing censorship by the governments in the countries where they're working or where they live. They have in the past noted that on social media, and that information has then gone to IDA where it can develop resources and programming, et cetera, to support its community of filmmakers and to alert other filmmakers that they might face those threats. It is in countries around the world where filmmakers like IDA's members face threat of persecution, et cetera, where they might be particularly likely to use pseudonymous social media accounts. But because they're now forced to disclose their identities to the US government.
But those people would have to know that they're going to seek visas in the future.
Yes, and we have identified individuals who plan to seek visas or who have already sought visas in the United States who, because of the disclosure requirement, have stopped speaking on social media.
What speech did they self-censor?
In our complaint, we identify many posts that relate to political speech, so speech about government policies, and let's see, Sorry, I'm just trying to be specific here for you. Another.
Mr. Director, I think the
Yes.
issue is you have to show concrete, immediate, particularized injury to your client.
Yes.
And I feel like what's in your complaint and in this record is really kind of amorphous. Like, oh, we use social media to do stuff. And I don't know that you've met that burden. You're showing that it's concrete and particularized. Because I think I think the law requires you to say, this speech is chilled. We would have used it in this way. And that is important to our mission or our thing. And I don't see those dots being connected.
Thank you, Ronnard. I mean, again, we think at the motion to dismiss stage, we have sufficiently alleged those injuries, but I do, again, want to emphasize that we have two other separate theories of standing. One is based on the plaintiff organization's hosting of events in the United States. These are their bread and butter activities. Their very missions are to bring filmmakers from around the world together at conferences and screenings and award ceremonies, et cetera, in the United States to support that community. And we've, for example, Doc Society's Good Pitch events that are hosted here.
Then can you walk us through what the analysis is for those people? Because now
Yes.
they're not applying? Like, I need to
Yes.
understand what is the injury to you.
Yes, exactly. We've identified a number of individuals who are now deciding not to apply for US visas to come to the United States because they fear that their social media information will be swept up into government databases and then potentially shared with any untold number of governments through pre-existing information sharing agreements, or simply used in a way that might delay future, sorry, that's a separate category, but individuals who are no longer willing to come to the United States specifically because of the disclosure requirement and the burden that it places on them and their speech online. So rather than being chilled in their speech, they're being deterred from traveling to the United States and attending events at plaintiff organizations that plaintiff organizations are hosting here, that without these events and without the participation of their international.
Are they sort of very specific people that you're pointing to here? Because then we're more like in Mandel land, like you have invited them, they can't come because of this? Or are you just saying just broadly, there are people who are not coming and they could have come to our events?
We've identified individuals who have decided not to accept future work here despite significant past work, who would have sought visas to come to the United States. A Turkish IDA member who is currently working on a project with US
But are we
partners.
still talking about organizational standing or now are we associational?
So still organizational standing because these people are not coming to the United States. And as a result, the plaintiff organization's events are suffering a loss of participation that goes to their very reason for existence.
So they would have come to the events. They were going to come for the events and now they're not applying for visas for your events.
They're not applying for visas to come to the United States at all.
But again, isn't that a little bit amorphous? They're not here, and if they were here, maybe they would have come to our events. Is that what you're saying?
Yes, but we do also identify an individual who no longer is willing to participate in screenings and question and answer sessions because his comments may be mischaracterized by others and shared on social media and then.
Those are
used
your
against him.
screenings? I mean, it has to be your client's injury. And I hear a lot of injury, but I'm having trouble kind of homing in on how it affects your client. Your client has to have immediate, concrete, particularized injury.
Yes, Your Honor. And we think that these allegations and the reasonable inferences drawn from them under the motion to dismiss standard support the connection between these members and partners who are deciding not to come to the United States and the result that they will not be attending plaintiffs' events here. But I do, want to put forward our third theory of standing as well, the associational injuries, the associational standing that IDA has based on the injuries suffered by its specific members. And I think the district court's analysis later on in its opinion is instructive here, where the district court concluded that plaintiff IDA had raised valid First Amendment claims in part based on its members who are currently in the United States and so who have kind of the full scope of First Amendment protections, who are being presently chilled by the knowledge that they will have to apply for visas to renew their visas or apply for new visas to remain in the United States and continue their lives and work here. And I'll just point you to the specific pages of the district court opinion that unpack this, I think, quite helpfully. The district court analysis at JA 361 to 364 gives a full explanation that we endorse as supporting our associational standing for IDA specifically because it's a membership organization. And I would note again that if the court concludes that there is specificity lacking in the complaint, we would very much welcome an opportunity to amend the complaint and provide that specificity.
Would you have had to have requested to amend the complaint on the grounds? Like,
we-
for example, if we think that you have not demonstrated redressability, which goes to all of your claims, in order for you to get a second bite at the apple, would it be required for you to have sought to amend your complaint to address redressability in the court below?
I don't think that level of specificity is required. We did ask the district court for leave to amend the complaint if the court ruled in the government's favor. And the district court concluded that it would have been futile to allow us leave to amend the complaint because of its legal conclusions that the disclosure requirement simply was not subject to review at all under the APA and subject to only very deferential review under the First Amendment. And those are the two key conclusions that we challenge here, in part because we think that the sweeping implications of those conclusions are simply far beyond anything this court or the Supreme Court has endorsed to date. So if I may, I'll turn to those arguments, but I see my time has expired. So
I want to ask one or two more standing questions, and then I'll ask my colleagues if they have questions on the merits, and then it'll be up to them whether we go into the merits.
Good.
Judge Pan just mentioned that if redressability is a problem for you based on the theory that you and I began talking about, that would mean you have no standing for anything, correct?
yes, Your Honor, but I think the redressability concern is pretty squarely answered in the Americans for Prosperity v. Bonta case, where the court said, concluded that a disclosure requirement, not terribly dissimilar from the one here, was facially invalid and reached the full merits of that determination, in part because invalidating the disclosure requirement would have addressed the chill that the plaintiff charitable organizations were complaining of, even though their donors could have been swept up in individual investigations into those charities' activities, in the future, notwithstanding.
Here, it's possible that an order in your favor would, and I'm going to quote some language the district court quoted from non-binding authorities, but an order in your favor would remove an impediment to the desired behavior. It would make the desired behavior far easier. It would make for better odds that the desired behavior would happen. But none of that is enough. What you need is something beyond conjecture, that even though consular officers can still demand social media profiles, these people will post the things to social media that they have stopped posting because of the challenged government.
Your Honor, we have alleged that but for the disclosure requirement, plaintiffs' members and partners would continue speaking on social media as they previously had.
That has to be a plausible allegation.
Yes, and we think it's entirely plausible, particularly in light of the Supreme Court's many decisions about the chilling effects of government disclosure requirement, again, as the Court on Americans for Prosperity Foundation termed it, that there's an inevitable chill.
What's your best case for, there are two government chilling policies. We're challenging one of them. And if we win on that one, we have a redressable injury. Never mind that there's still a second government chilling policy.
I think Bonta is exactly that case, Your Honor. I mean, the California AG's office could have always conducted its own investigation. And in fact, the court looked to that possibility of conducting their investigations.
In this context, the government is going to investigate every single visa applicant.
But is not, excuse me, Your Honor.
Please go ahead.
Sorry, there is no guarantee that this particular information will be requested because it's an additional just opportunity for a consular officer. And this goes to the point that consular officers, in terms of the evidence that has been put before the agency, don't view it that helpful.
You're positing a weirdly sort of half risk averse, half risk welcoming, unknown visa applicant whose speech we don't exactly know what it's going to be. And this visa applicant is risk averse enough that they won't post because they're sure they have to turn over their social media profile, but they're risk welcoming enough that they will post even though there's going to be an investigation of them when they apply for a visa, and that investigation might ask the very question that chilled them from posting in the first place.
I think the difference could be a 1% possibility that that information is requested on an individualized basis and a 100% guarantee that you're going to be forced to disclose it at the outset, even though it might not be relevant to the visa category that you're applying to.
An unusual gambler. Fair.
And you're assuming that they're all going to think it's a 1% possibility, but if you're worried that you have postings that would affect you or could be divulged to hostile governments,
To be clear, Your Honor.
you're going to weigh that heavily.
If I may clarify one thing, it's not that the members and partners are considering their social media kind of at most as directly relevant to their visa application. They're simply concerned about the likelihood that it will be reviewed, notwithstanding the fact that it's not relevant to their application and misconstrued by the government, or even not misconstrued by the government, that they are allowed to enter the country, that it doesn't impact their visa application process whatsoever, but then it's stockpiled in government databases and potentially shared with threatening governments in the future. So again, the concern here isn't even necessarily that they would be denied on the basis of the social media information that they're disclosing to the government under this requirement, but simply the harm that government disclosure requirements kind of inevitably have, as in Shelton v. Tucker, Bonta, and many other cases dating back many decades.
Ms. Giselle, let me ask, Charles, do you have questions on the merits? Do you have questions on the merits?
No.
I don't think we have any questions on the merits, but we do have your very excellent brief on the merits, and it will be considered.
Thank you, Your Honor.
Mr. Brewer.
May it please the court, Simon Brewer for the government. The plaintiff organizations lack standing to bring this challenge. They are not directly regulated by the disclosure requirement that they challenge. So instead, they rely on a series of attenuated harms purportedly arising from third parties' reactions to the disclosure requirement. But as recent Supreme Court decisions make clear, those purported harms do not support Article 3 standing. Starting with the organizational injuries alleged, Alliance for Hippocratic Medicine clearly forecloses the diversion of resources theory pressed by plaintiffs. That leaves only their theory of informational injury, which itself is also foreclosed.
You believe the plaintiffs have to have a legal right or entitlement to the information. They can't just rely on it.
That is what the Supreme Court said in Alliance for Hippocratic Medicine in that sentence read by Judge Walker earlier.
How does that square with DC Circuit precedent?
To the extent prior DC Circuit cases came to an opposite conclusion, they have been abrogated by the Supreme Court's holding.
Was it a holding?
I think it was, Your Honor. The Supreme Court said that the plaintiffs hadn't alleged such a theory, but then even if they had, it would still be foreclosed under the Supreme Court's case law. So
if we were to go with you, is there any cleanup in our case law
I think what
necessary?
I think what Your Honors could say is that to the extent that prior DC Circuit precedent left open the possibility or perhaps even endorsed the idea that a statutory entitlement to information was not required, following Alliance for Hippocratic Medicine, that is no longer good law. Turning to their First Amendment harms, Murthy makes clear that they can't rely on this listener theory of standing either. As an initial matter, it relies on speculation about causation and redressability, as the panel's question suggested earlier. These are speech posted online by third parties. Those third parties may choose to post or not to post for any number of reasons outside the disclosure requirement. And in addition, and Murthy makes clear that such speculation does not support an Article 3 injury. Plaintiffs also lack the kind of concrete and specific connection to the speakers that is required under the Supreme Court's case law to give rise to this listener theory of standing under the First Amendment. On turning to the associational theories, unless the court has any questions on the organizational theories. To have associational theory of standing, the plaintiff organizations would need to identify a specific member of plaintiff IDA who would have standing in their own right to press the challenge that is sought. And they clearly have failed to allege enough facts that would support such an associational theory of standing. There is one sentence in the complaint about a member of IDA who lives in the Midwest who has purportedly reviewed some of their social media and deleted certain posts. There is nothing in the complaint about whether or not this person will be required to apply for a visa in the future, when that might be, kind of visa, and so forth, that would allow an assessment of whether or not this actually inflicts a concrete and imminent injury on them, as opposed to being an independent decision made by this person, absent any sort of imminent injury or concrete fear.
What about the judicially manageable standard of review?
Yes.
The use of the term necessary.
So turning to the merits, assuming that one or more plaintiffs have standing, the statute does not provide any judicially manageable standard. And I think the key here is that the term necessary standing alone isn't the right way to look at this question. And the statute directs the secretary to collect information necessary to, among other things, the enforcement of federal nationality and immigration law. And that provides no judicially manageable standard. If, for example, a statute directed the FBI in the course of its investigations to collect information it deems necessary to carry out its law enforcement and investigatory functions, we would not expect courts to be second-guessing its judgments about what kind of information is necessary for those investigations. And so too here, the State Department has been tasked with investigating and enforcing immigration and nationality laws, and it has made a reasoned judgment that this type of information contributes to that investigation.
You talk about redressability.
Yes, Judge Pan. So to Your Honor's question from earlier, there's a real redressability problem here because the plaintiffs have conceded that consular officials can collect this information as part of individual visa applications. And Murthy indicates in that kind of scenario, redressability is lacking because the plaintiffs had similar incentives to moderate their own content posted on social media. So whether or not the visa collection policy, the information collection policy challenged here remains as part of the visa application, visa applicants have similar incentives to consider what they're posting on social media and knowing that public posts could be reviewed as part of the visa application process.
And as a procedural matter, there was a motion to amend in the court below that was denied. Is this something that we can just decide in the first instance, or should it be remanded?
Standing is, of course, something that the court can decide in the first instance. And in fact, the court has an obligation to address jurisdictional issues, of course.
Of course. But if I guess the question is there any way that they could provide more evidence that would support standing under these circumstances?
I think the fundamental standing defects here are multiple and would be.
I'm specifically focusing on redressability because presumably they could get an affidavit from somebody that says, if the rule is vacated, I will post again, even though there is this chance that the consular official will ask me the same question later.
One would think that if that such a person were willing to say that, it would have been included in the complaint in the first instance. But to the extent Your Honor is concerned that plaintiffs might be able to come up with such a person, I think that speaks to the fact that there are other independent grounds why standing is lacking here, and so a ruling on those would clearly foreclose.
Well, I'm just focusing on redressability. If we think that that's the problem, does that need to be a remand, or can we? Or do you think that there's nothing they could do to amend their complaint to address that redressability problem?
I think if plaintiffs were able to come up with such a person, it would have been included in the first instance.
And there's some language in, I think it's Murthy, that what because they're seeking a prospective, relief. They'd have to not only show that. They have to show that going forward, that person would post something, but will not post something absent the relief. That's easiest to support by showing that it's happened in the past. That same person has been chilled in the past. I guess they wouldn't have to show that the person had been chilled in the past, but what do you think?
That's right. So the essential question for prospective relief is what is going to happen in the future? Is there some kind of imminent or ongoing injury?
It's really hard to show that if it hasn't happened in the past.
Right. And that's exactly right. And so one of the difficulties faced in Murthy by the plaintiffs was this inability to show past injury with respect to traceability and causation. And so that, of course, will make it more difficult, but ultimately for prospective relief, the question is about the future.
Right.
I'd be glad to answer any other questions the panel has.
Judge Jones? Judge Pam? I think we have your argument.
We urge you to affirm. Thank you.
Mr. Brewer. Ms. Distel, your rebuttal.
Thank you, Your Honor. I'd like to just make 2 points on redressability to address the court's concerns. So first, with respect to the kind of probability question, we think there's a significant difference between a guarantee that you will be run over while crossing a multi-lane highway and the possibility that you will be run over if you cross a crosswalk at a red light. We think that's the difference between the dragnet, boil the ocean approach to collecting social media information that the government has taken here and the individualized application-specific approach that consular officers are allowed to pursue under pre-existing authority. Second, the Supreme Court in the Department of Commerce case did address a situation. We think that it goes even beyond the situation here, where the party states were concerned that the addition of a citizenship question to the census would result in fewer people completing the census. And the Supreme Court held, and the court in Murphy cited this decision at length in a footnote, that third parties will likely react in predictable ways to the citizenship question, even if they do so unlawfully because they're required to complete the citizenship application, and despite the requirement that the government keep individual answers confidential. So there, and I'm quoting from this case, the court held that respondents' theory of standing does not rest on mere speculation about the decisions of third parties. It relies instead on the predictable effect of government action on the decisions of third parties. And that's what we've alleged here as well. For no further questions.
I think that's helpful, and I think your metaphor about the road is extremely helpful. I'm not sure if I'm persuaded, but that was a very strong metaphor. So appreciate it. Thank you for your argument.
Thank you very much.
Case number 23-1235 et al. Hood River Distillers, Inc. petitioner versus National Labor Relations Board. Ms. Petrova for the petitioner, Ms. Beard for the respondent.
May begin. Thank you.
Thank you. May it please the court, Sasha Petrova on behalf of petitioner Hood River Distillers. I'd like to reserve 2 minutes of my time for rebuttal, please. The board's decision in this case effectively means that no matter how diligently an employer pursues bargaining with a union, no matter how long the parties actually bargained for on the same critical issues, a union can still avoid impasse by simply denying that it exists, making incremental 11th hour movements, and then placing conditions on bargaining that it knows are impossible to meet in order to avoid having to test an employer's last, best, and final offer. The record in this case does not support the board's conclusion. For 14 months, HRD attempted to make a new agreement with the union. HRD offered upwards to 80 bargaining dates with the union. And from
Ms. Petrova, are you aware of any cases where a court has concluded that there was no valid impasse when the parties negotiated for 14 months or more?
I'm not aware of such a case.
If we agree with you that there was an impasse, should we vacate the board's order in its entirety?
We did make a couple of concessions in our reply brief as to which parts of the board's order do not directly stem from the impasse determination. But for the most part, the impasse determination here is what drove the majority of the violations findings and the consequential, the remedy that was actually implemented.
I don't understand if that's a yes or a no.
Yes, please. We would like to, yes, we would ask that if you find an impasse that we would vacate the decision and reverse.
Do you know, moving from impasse to dilatory tactics and bad faith, do you know if this court has ever relied on dilatory tactics to conclude that an employer had a right to unilaterally implement its last offer?
Your Honor, I'm not aware of any instances of this court actually finding that that exception would apply. The one case that we discussed in the briefing is the Saramonte Oldsmobile case. And in that case, this court found that the exception to impasse rule didn't apply ultimately because the challenge delay was about a month for the union to come to the bargaining table. And when it did get there, the union apparently didn't make any specific proposals or counter proposals on that date. And in that case, the ALJ found that the evidence was not clear as to which party was primarily responsible for that month of delay. And so under those circumstances, there was no exception to impasse. But here we have something much, much different. And I think the briefs adequately explain the length of delay, the overwhelming amount of time that HRD spent.
Let's talk about the 14 months, because it seems to me that there was a lot of progress in the first 7 months and you came very close to reaching agreement, but then it was HRD that sort of scrambled the negotiations because HRD made a decision that they really wanted to focus on healthcare, and there's like a balance between like, should we focus on achieving our goals on healthcare plan versus wages? And it seemed that after 7 months of negotiation and people got very close to a deal, HRD changed its focus. And then we're looking at the second half of the 7 months. And then there was a month where there was delays in January where it was nobody's fault, but ice storms, medical things happened. And then they start negotiating again in March. And then on the last bargaining day, it was productive. There was movement. And then there was an HRD email that said, I appreciate the progress the parties made today on healthcare. However, the company and the union have come as far as they can go on the other open matters. But it's hard to say that you're at the end of your rope and it's an impasse when you've just said, I appreciate the progress we've just made. And there was movement on wages as well, because both you moved, you added an extra year to the bargain. You had said we want 1% for these 3 years, and you've added a 4th year. So you moved on wages, and they moved on wages because they said, now we're going to accept something lower than what we had originally had. So it's just really hard for me to see that there's an impasse, given that the last time you bargained, there was movement on both sides.
So, Your Honor, we would take issue with that characterization of the record in some respects, because at the very start of bargaining, it was made clear to the union that there were going to be significant concessions requested on both healthcare and wages. And from the start, there was a wide gap. I believe the first offer was a 6% total increase in wages from the union at the very start of negotiations, and no move to health plan. Now, by the end of negotiations, yes, that gap on wages decreased, and the union proposed potentially to move to the employer health plan.
That seems like huge progress.
After 14 months of back and forth,
well, I kind of look at this as the back 7, because the first 7 was productive, and the reason it got sort of wiped out was because HRD changed its position.
Respectfully, we would disagree. HRD has been consistent that it would not entertain a wage increase of higher than 1% since about September.
But on March 30th, you added a year, which is a change. That's a change to your wage negotiating position.
So that change was based on the fact that the parties had been negotiating for 14 months. So it basically was essentially made in order to make sure that the parties actually entered into a 3-year prospective agreement rather than something much, much shorter.
Okay, but you changed your position. You added a year. It's a negotiation about wages. You were saying 1% for these 3 years. Now you're adding a 4th year. So that's a change in your position. I'm just saying it doesn't look like an impasse to me when you're making a new offer on wages.
It was a new offer on only in the length of the actual contract, but effectively.
Correct, that's real money because the 1% builds on what's come before it. You've changed your position on wages.
I think the bottom line, though, is that the 1% increase, we never strayed from the 1% increase. And despite every offer that was made to us, suggesting 2.5, 2.25.
You never strayed on the amount of the increase, but you strayed on the number of years it covers, which is a different amount of money. So it's a different change in wages.
So, and I think with the bottom line being that it was still much more, a bigger increase that HRD was willing to entertain. And it had explained that position very clearly to the union on the 30th. And I don't think,
I just, the point is, this is a deferential standard of review. We just have to see if the board's decision is supported by the evidence. And the board says this wasn't an impasse. There was all this movement on March 30th, which was the last time you bargained. And that's supported by the evidence. You moved and they moved. March 30th, that's it.
so
That's supported.
there was movement at the last bargaining session, but it was very incremental. And the point here
It
is
doesn't
that
matter. It's not an impasse. You're not at the end of your rope.
we were at the end of their rope, and we specifically said that in our last best and final offer. There's no reason
You
to
said that
doubt
for the fifth time. At that.
our position on that, and I will address that certainly, but that it was actually one prior LBF. But the point being here is that there was an offer on the table that said that we as the employer are unwilling to move any further than the final offer. And it was communicated very clearly. And in response, all we got was, we're not going to meet with you further unless it's in person, which was impossible at the time. And so, our position is that we were at the end of our rope. There was no reason to doubt that we were at the end of our rope.
Except that you said you were at the end of your rope 4 times before and you weren't.
Right.
You kept negotiating.
So our position is that we were not at the end of our rope 4 times, and it was one LBF, and I'm happy to address that. So
Well,
that-
the issue is, have you used the same or similar language when you were acting like you were final, in your decision-making? Such
so
that we would then say, well, it didn't appear to be final because you said it before.
I think there was significant difference in the LBF that came in March 30th. So first, it was issued through HRD's attorney, which the prior offer was communicated through the HR manager.
But I'm asking about language.
Yes, and the language specifically in March 30th, it made clear in very certain terms that there was no more room on wages, and the record reflects this. And so it was qualitatively different. And the first LBF came at the heels of about 1.5 months of HRD not hearing back from the union after making its last proposal. And as the court is, I'm sure, well aware, impasse is intended to continue negotiations. It's a point in time, and it can be overcome. And so here, the record does not reflect any indication that HRD made the last best offer initially in any bad faith. It wanted to continue negotiating with the union. It was attempting to schedule
But
for.
the issue is just the credibility of you declaring an impasse when you've previously done so and it wasn't real. Like, how is the union supposed to know when you mean it and when you don't, when you just do this as a bargaining? There's evidence in the record that your HR person said that you would declare an impasse without meaning it. This is JA 2094 to 96. Human Resources Manager Janine Summerfield.
Mhm.
If we were still not going to hear anything or any movement from them, we were willing to take the next step. Yes, we were hoping we would get back to the bargaining table. That's in response to a question about why did you declare an impasse? They just wanted to set dates and they would declare an impasse. And then the question was, I believe you testified that this declaration of impasse, you really didn't mean to declare impasse, but this was more of a bargaining strategy to get the union back to the table. Do you recall that testimony? Answer, yes. Best case scenario, that is what we were hoping to do, to get some bargaining dates on the calendar and not to have to declare an impasse. So you're strategically declaring impasses throughout this negotiation. How are they supposed to know when you really mean it?
I would, again, disagree that, sure, there was a declaration of impasse, and it was intended to bring the union back to the bargaining table. There is nothing in the record that suggests that that's a nefarious intention, that we.
I'm not saying it's nefarious, it's
Yes.
just that when do we take it seriously when you're declaring an impasse? When sometimes you do it just to get them back to the bargaining table, and then sometimes you do it and then all of a sudden unilaterally impose your own terms.
I think in this case, it is very clear at the end, again, a very detailed letter was issued by
Sound like, I mean it this time.
there is a different gravity coming from a party's attorney, I would say. It imbues the offer with legitimacy. This is our final bargaining position. We are using the word impasse because we are at the very end of our rope, and we are.
Saying the other side of the table, they're supposed to be reading into what you're saying, depending on who's saying it. I feel that's not their responsibility. It should be your responsibility to speak with one voice when you're negotiating.
So sure, but a position can change. And so after, the first impasse declaration was about, I think, 8 months into the negotiations. Now we're at about 13 to 14 months in. It has been a protracted negotiation, and there's nothing here to suggest, this is important, I believe, that there's nothing here to suggest that the union was actually confused about whether the last offer was a last best final legitimate offer. The union reached out on May 1st, the date of implementation, said, hey, can you guys hold off on implementing the offer? So the record reflects that the union understood this was going to be implemented, and it had an obligation at that point to respond. There's nothing here to suggest that the union was confused, and that's why it didn't respond or didn't engage with the last best and final on March 30th. So I think that's very important because the union could have reached out to test this, and I'm not saying that it's the union's obligation necessarily, but the evidence shows that there was no confusion. So any contrary finding that it detracted from the legitimacy of HRD's ability to issue a final offer?
So their response was, let's have a face-to-face mediation. And you're saying, well, that's impossible. But at that time, it wasn't clear how long the pandemic was going to last, because we're talking March 30th. This is early days of the pandemic. So that doesn't seem to be a dilatory tactic. It doesn't seem to be an unreasonable position to take in that moment. Like in retrospect, it's like, well, yeah, we're talking a long pandemic. But back then, they didn't know that.
Sure. So we're not contesting the fact that the union might have at some point thought that the pandemic would only last a couple of weeks. What we are contesting here is on the evidence in this case that.
But they don't think it's over. They want to continue mediating.
They don't want to continue meeting because we've
They asked
repeated.
for face-to-face mediation.
They didn't ask for it. They insisted that any further mediation, meetings that
But they
occur.
want to keep talking.
They don't want to keep talking because so respectfully, we disagree. The record reflects that every time that we reached out, said we are more than happy to meet with the federal mediator. By the way, something that HRD initially suggested and the union declined to accept the offer to mediate with a federal mediator.
This still comes down to deference to the board's findings and what those findings were particularly stated on the record, with respect to the negotiations. So how can you get us away from that?
So correct. This is a deferential, generally impasse is a deferential issue, but this court clearly in its jurisprudence does not rubber stamp any impasse decision and does consider the record as a whole. Our position here is not that there's a credibility finding that we're disputing. So we're not saying.
You also agreed to mediation, just not in-person mediation. So that even moves the ball further to say it wasn't at an impasse.
So the fact that we continually left the door open for the union to break the impasse, that should not go against HRD. Clearly, impasse, again, is a moment in time. It is a deadlock that is intended to be broken. It's meant to be broken. That's the whole point. We want parties to reach
But
agreement.
impasse exists where the parties have reached the end of their rope. And if you're leaving the door open, you're not done.
The record, and I would ask that the court review the record site specifically in the reply brief on this. The record is clear. We communicated. We are at the end of our rope on wages. We have rejected multiple times when the union has proposed something.
Was healthcare dealt with? Were you done there?
So towards the end, there was a potential agreement on moving to HRD's healthcare, but the main sticking point, the wages, something that has communicated as one of the most important issues in this entire negotiation from the very beginning, there was no further room on that. And just because the union says, yes, we will continue negotiating, or there is further room, that alone cannot defeat impasse because.
So can we just review what happened on March 30th?
Yes.
You proposed a 4-year contract. That was the first time you'd gone to 4. You said the employee should switch to Blue Cross BCBS and receive a 1% wage increase in the 2nd, 3rd, and 4th years. So this is a new offer on wages, because before you were only talking about a 3-year contract. And now you're talking about a 4-year contract. The union agrees to the 4-year contract. They agree to switch to the BCPS. And they agree to a wage increase in the first year, and they propose an average wage increase of 2.5 in the last 3 years. So you still have to talk about that, but they're moving. And that is an overall lower wage increase than before because of the freeze in the first year. And then you say that's regressive, they disagree, but then they move again. They propose a 0.25 wage increase reduction for each of the contract years that they had proposed. This seems like a lot of back and forth and a lot of movement on both sides. So that's why I'm just really flummoxed by the idea that there's an impasse at this point.
So I'm going to back up to the last counter proposal that happened, I believe it was on March 10th. So the union's counter proposal was either that they stay on OPET with no cost sharing with a pay freeze, or that they move to HRD's plan with a 2% wage increase each year and it's retroactive. So the general negotiations reflect a pattern of giving on one thing, insurance, while regressing or being unwilling to move to HRD's final position on wages. And so then on March 30th, sure, HRD proposed that the new expiration date would be February 2023. So again, it's not necessarily a 4-year contract. It's to make it a prospective 3-year agreement. Again, because we've been bargaining for 14 months here. So the union's counter proposal, it accepts the HRD health plan, but it offers wage increases of about 2.5% per year.
But
which,
with a freeze in the first year.
With-
And the math was done, and that was coming down on wages because of the freeze.
So this is where we certainly disagree with the math being done, because first of all, the ALJ did some calculations and took testimony of understanding that was
But
not.
he laid out his calculations and they work, and you don't have a counter calculation.
So the ALJ is not permitted to sit judgment on the offer. And the only evidence in the record, and I can point you to that's JA 2175 to 81, is that HRD did its own analysis of the counter, and it did determine that it was regressive and that there was no further room for movement.
But the ALJ's math is in the record, and I looked at it and it works, and you're just saying, we have a contrary opinion without saying what that is. And again, this is a deferential standard of review.
Again, the bottom line here is that HRD's position was that it was unwilling to move any further on wages, and concluding
But
that.
on March 30th, you went to a 4-year contract, which is a move on wages, and the union moved on wages. They changed their position to say, we'll take a freeze in the first year, and then this increase in the latter years. And then they moved again and said, we'll take a smaller increase in the latter years. How is that an impasse?
So the impasse here is that we are still leagues away.
So the impasse is you just haven't reached an agreement.
The impasse is that despite communicating multiple times that we are no longer moving on wages, we were getting.
But you moved on March 30th.
But, and there is no, so I guess the point being is that the act does not compel agreement. It does not tell a party, it does not tell an employer that it must accept a concession on wages or
No,
what
it
that.
doesn't. All we're trying to figure out is if there's an impasse, you're both at the end of your rope. There's a finding that you weren't, and it's supported by the evidence.
We disagree, because at the end, it's at least 2 times higher than the ultimate position that we were willing to take on wages. And again, because there is no compulsion to reach agreement, HRD's final offer should be credited. It should be allowed to
You're asking
draw.
us to make a credibility finding?
No, we are not.
Then why are you saying that?
We are, because that's effectively what happened at the board. So the board effectively said that HRD's final position couldn't be final because there was further movement to be made. But again, the union never represented what that movement could be. HRD expressly put forward, let us know if there's any further movement on wages. And the union never responded. It never had any indication of how the parties could reach agreement on wages. And that to us represents impasse. I see I'm over my time, but
Nothing else.
thank you.
We'll give you 2 minutes on rebuttal. Ms. Beard.
Good morning. My name is Heather Beard for the Labor Relations Board, and we seek enforcement of the board's order in full. I think the discussion just now demonstrates the board's position that substantial evidence supports its finding that the company didn't carry its burden of establishing impasse. Now, my colleague Hood River presents what is its alternative view of the record, but that is not something under the standard of review of this court is compelled to accept. So I would boldly stand here and declare that the discussion between Judge Pan and my colleague, I would like to say that we agree with all of the points that Judge Pan was making in terms of all of those issues with regard to the impasse finding. I would like to circle back, if I may, to Judge Walker's initial question to my colleague about the length of the negotiations. I'd like to address that. So first, what I would say about that is the board itself recognized, and in fact, a finding in terms of the support for the length of these negotiations was the fact that the company initially was asking a big ask. The company was saying, we'd like to save a lot of money. Great, fine, nothing wrong with that, okay? Because of that, what the board found is that protracted negotiations could be expected. An impasse finding is one where both parties exchange offers, move, and then determine whether or not they can have a contract or that they're end of the rope. This is exactly what happened here. So there is, in my view, there's a lot of cases with a lot of months and a lot of factors in impasse. That's the exact issue here, which is the board take.
My question, Ms. Beard, was, are you aware of any cases where a court has concluded there was no valid impasse when the parties negotiated for 14 months or more?
I do not know as I stand here, unfortunately. However, I believe there are cases where there are similar months, like the length of negotiations has been long. There are many cases with that. But that's one of 5 factors, and this is not, so that's my answer to that question.
There was September 27th, 2019 offer from Hood River. And there was a March 30th, 2020 offer. You're looking at, like, maybe you want me to describe the September offer? Or do you know what I'm talking about?
I know exactly what you're talking about.
Okay.
That's cool. I got it.
What's the difference between those offers?
Right. So on September 27th, the Hood River offer was not an offer for a 3-year, it was an offer for a 3-year, not a 4. Are you asking March 10th? I'm sorry, or March 30th? Because I know that on March 30th, as Judge Pan was stating, they were saying we will do a wage freeze in the first year, but we will have a 1% increase in the back end on the last year of the contract.
Wait,
So
sorry, can you say that a little slower?
I apologize. So excited about this.
Everyone left after the last argument, so if they had known how exciting.
I mean, impasse is the most exciting of all the labor
It's kind of
relations.
insulting to you all.
So on March 30th, negotiations were going on prior to March 30th, and days and months were passing. And so what the company was doing is saying, let's, at the end of the contract, let's add on another year of the contract. And in response to that, we, the union had moved in that meeting to say, okay, that's fine, we'll give up our retroactive to the date that the contract would have started offer. So the difference between September, the offer in September of 2019 was the company saying, we will give you at the last 2 years of the 3-year contract, we'll give you just a 1% increase, and we're not going to give you retroactive to the date this contract would have started. So the wages were different in the offer of March 30th. The other thing that was different is that the union, okay, that's one other thing I need to emphasize here, whether or not Hood River thought it was at its end of its rope is not the end. To torture that metaphor, it's not the end of the discussion. There has to be a contemporaneous understanding of the parties. And the union was not ever at the end of this rope, is what this demonstrates. But nonetheless, the offer that HRD made was different in terms of wages, and the union had moved to, by March 30th, say, okay, we'll give up our great health insurance plan and we'll move to HRD. And what the board recognized is in that move.
But I just want to make sure I have the answer to
Yeah,
the question,
yeah.
which is the only difference between the September 27th, 2019 offer and the March 30th, 2020 offer was this kind of 3-year versus 4-year retroactive date issue.
There also was in the union access, there are 2 other issues besides wages and pension. There was a union access policy when the union comes on to the plant and they're not also employees, how much of a, how many hours do they have to give in terms of notice that they're there? And at one point, HRD, and I believe it was between September and March, that HRD gave up one of the things it was asking for, which was we want you to have 24-hour access. There was some movement there that HRD gave up the 24-hour access.
That seems pretty on the margins.
Well, that was one that you asked me the difference.
No, I know,
Yeah.
I want a complete answer, and then now
Sure.
my follow-up question is, and that.
Sorry,
that
can I
is-
just, I think a big change too, wasn't it? September was where they decided they're switching to BCPS.
Thank you,
From
Judge.
Cigna, which is an important change.
Yes, thank you, Judge Pan. That was an important change because the switching to the HR plan does not like, as Judge Pant said, it doesn't include something significant, which is the healthcare change plan. And that meant that the company was giving different benefits. And in fact, the union needed to give that sort of analysis, get a third-party analysis and communicate it to its
We'll
employees.
get to the
Yeah,
analysis. But-
sure.
So I just want to make sure I have this. So there's the 3-year to 4-year change. There's this union access policy, and then there's a switch. So after September 27th, 2019, there was a switch from Blue Cross Blue Shield to Cigna.
That's correct.
From
There-
Cigna to Blue Cross.
The
The
Cigna
other way
to-
around. Okay, and then what's the, and what, then you were maybe going to tell me one other?
Yeah, there was a discrepancy throughout about language for the 401k plan. And the 401k plan was what was going to be the matching formula that the employer was going to do. And the contract previously had some language that the parties went back and forth over. Should we change the language? Is the language okay? Should it be 230? There were all sorts of arguments about that. And the thing that matters is that in the March 30th offer, the company had a little asterisk next to it accepting the union's access policy and said, if you accept the union's access policy, we'll accept your 401k policy. So they were willing to exchange those two proposals.
Okay, then new questions, but still somewhat fact related, questions for you. You say in your brief that Hood River repeatedly labeled its offers final. You provide 3 dates, November 1st, 14th, and December 17th.
Or December 14th.
Yeah, it could be, maybe, okay. A date in December.
Yeah.
As I read the ALJ's fact findings that were formed by the board, all 3 of those dates refer to the same offer. Is
The
that
September
correct?
27th offer. That's
Okay,
correct.
great. And then grateful for your patience here. Just want to make sure I have the facts, all the facts right. In February 2019, Hood River suggested a mediator. Sorry, it's February 20th. February 2020. In February 2020, Hood River suggested a mediator. And at that point, the union said they didn't think the mediator was appropriate, right?
Correct.
Okay, and then the government, that's the last case.
We're the government.
Yeah, well, all 3 cases
Yeah.
today. The governor's, executive orders in March of 2020 about COVID prevented an in-person meeting between Hood River, the union, and the mediator. That's correct, right?
I would love to just say yes, but I'm going to say yes, but if you'll let me. Yes, but there is a discrepancy between when you say with the mediator, the union believed, and again, important is what the union and the company believed, that the mediator would agree to meet in person, but the company and their communications with the mediator believed that the mediator would not do that. So parties disagree as to what the mediator would do.
The governor would not.
The governor's orders, yes,
The governor's orders.
governor's orders said at that point, at one point, the governor's orders, like it was everywhere, was changing 25. And so I'm not sure that exact point, if it was the 25 people in the same room. And I would note that as we note, and it was in the facts, Hood River in its March 30th telephone meeting did have its principals in the same room, 6 feet apart in distance. So I don't want to quibble over that. There was just.
And I'm not asking what each side believed about the governor's
Okay.
orders. I'm just asking you.
Right. I would say that the governor's orders, I'm not sure. I'm going to say I don't know. I don't know if the governor's orders strictly precluded any in-person meetings the way that maybe the union would have sent one person. They never agreed to do it without a mediator.
Not
and
that the
in-person.
order prohibited in office as long as telework was possible.
Right. I'm gonna
That's how
actually,
the ALJ said that.
yes, if that's what the ALJ said, then that's,
Well,
and the board affirmed it. I'm
I
gonna
don't
go.
want.
No, I apologize. I do think, though, that shows that at the time, people were trying their best in good faith to figure out what the orders meant and if they could do what they wanted to do within them. And I don't want to suggest being glib about how serious COVID was.
Right. No, I didn't take you to be risking that. In June 2019, the union proposed a 2.5% wage increase. Am I remembering that right? It might not be.
Yeah, I think it was 2.5 in June. If you give me 1 second, I can give you the exact. Yep. the union's proposal, after they gave, their what if proposal. Yes, they said if you were going to take the offer, that was not going to be, actually, they said, look, in the what if proposal, we'll freeze wages, and that's what they said in June, and that was what was rejected. So I guess your question is, what was their movement on June 25th?
No, I'm eventually going to get to what was their movement after this, but I'm just trying to
June
pin
20,
down,
okay.
pin down what they were saying in June 2000.
Yes, in June 20.
About wages.
Yes, June 24th, they made their third contract proposal, which they went from their original, went from 4% in the first contract year and 3% in the second and third contract years to a 2.5% increase in each year of a 3-year contract, with a first increase that would be retroactive to March 1st.
Okay, and then I think 9 months later, the union proposed a nearly identical offer. The only difference was that it was a 2.25% wage increase.
Right, they moved a quarter reduction in that
With the
percentage.
wage freeze in the first year.
Correct, yes.
And so
With the-
those were the only differences.
Those were the significant differences, along with the change in the healthcare plan that the union agreed that it would switch to, which again opened up a lot of other, but I know you just want to stick to the fact questions.
Well, no, I am trying to figure out. So the proposal from June 24th, 2019, fast forward to March 10th,
Okay.
2020, those offers were, and maybe this is the same, I guess the same question I asked. So, no, it's not, it's different. So those offers were nearly on the key issues identical, except for they gave up 0.25% on wages. And what else?
And accepted a wage freeze in the first year.
Accepted a wage freeze in the first year.
Yes,
Okay. Then,
And they switched their healthcare. They
The
agreed to the healthcare.
and they made concessions on healthcare. On the question of good faith and dilatory bargaining, the union, Hood River made an October 4th request for availability, and that was not answered until December 11th. Is that correct?
there were times like that where the union did not email the employer back right away, and vice versa. However, those time gaps,
What does that mean?
there were times when the company didn't respond right away to the union either, so there were
there
delays.
times where the company waited 2 months and a week to respond
No,
about availability?
no.
Okay.
The company, though, during that time knew that what the union was doing is trying to assess the healthcare plan and compare it.
Well, that's my
to
next
its healthcare.
question.
Go ahead.
So on, not the first comparison, but the second healthcare plan comparison, which occurred after Hood River switched providers,
Right.
that took 2 months. My first question, that new plan was, would you say materially identical to the old plan or materially different?
I am not aware of whether it was material identical or not. I know that there was no finding and there was no evidence that the union delayed purposefully in getting that third-party assessment. And in fact, I also know the union on March 30th, importantly, this answers one of the questions you were talking about with my colleague. The union did say where its movement could be when the union was asking, and Hood River eventually was provided this after March 30th. They wanted to know the cost that would save Hood River to go to Blue Cross Blue Shield. And they wanted to know that because, as the union bargaining agent testified, if there were significant cost savings to Hood River from the new healthcare plan, separate from what the benefits would be to the employees in a different way, those were things the union could consider in formulating its next wage offer. So for example, the company was not going to be saving a significant amount of money. The union may not have had in its wage offer something higher. So
Now, I understand that a comparison between the two health plans would be important for the union's negotiating position.
right.
And I take you to have just said there was not a finding that the 2 months it took to run the comparison was unreasonable.
Right.
I don't really see why it should take 2 months to compare two health plans, especially when I think federal employees only have 3 weeks during open enrollment to compare their health plans, and unlike the union, it's not our job to compare health plans?
Well, is it correct that
I
between
just give the
December,
answer to that.
between December 4th and January 9th, it was the company that didn't get back to the union?
There were right, there was not necessarily a 2-month, 2.5 month, as you just described it, Judge Walker, but there were times the parties didn't get back.
But that was a month that the company.
The company,
gave
yes,
to the union
absolutely.
From December 4th to January 9th.
Yes.
And then between June 24th and July 22nd, also 4-week periods.
Right, but I'm
Yes,
just saying,
and-
once the union had the 2 health plans to compare,
Right,
how long did it take?
right. I think the first time when it had Cigna compared to OPA, it took 5 weeks.
Okay.
And it took, I believe, as you said, 2 months for it to compare now. And I think
Okay,
that,
and so that's my question on the second one, that it took them 2 months to compare. Why?
right, because they wanted to not only make sure that the employees had comparable benefits to what they had under OPET, but they also had to check with their employees to see what their employees would accept before they could get back to the company. This was something that was thrust on them just then. And I would say, as a federal employee who looks at my healthcare benefits, sometimes it takes me longer to decide what to do. And I think that in this instance, because they had done a comparison of OPET to Cigna, and then looking for, oh, now the company wants, instead of Cigna, to do Blue Cross, they took them some time. And I think the key, though, to this court's review role here is whether or not it is, the view of the evidence is compelled here, that the union in some way was dilatory throughout these months. And that is just not what the record shows.
I mean, I think that 2 months to compare 2 health plans and 2 months, October 4th to December 11th, just to respond to an email about availability strikes me as quite dilatory, never mind requiring or insisting on an in-person meeting when it could easily have been done by Zoom, and no one was allowed to meet in person. Strikes me as somewhat dilatory, but would you say we are at an impasse?
I would say we may be at a good faith impasse. But we can break the impasse, although this isn't a case about breaking any impasse when there wasn't one to begin
Fair
with.
enough.
So,
We ask my colleagues if they have additional.
No, thank you.
thank you.
Okay, thank you. Very good argument, Mr. Ms. Petrova will give you 2 minutes.
Thank you. I'm going to try to succinctly cover a couple points. So the first is on impasse. So to the extent we're not talking about exception to impasse, I did want to just highlight that this court held in Mike Sal's Potato Chip Company that if an employer is firm during bargaining as to one or more of the essential issues, and Judge Pan, I know your concept of how the positions shifted slightly towards the end, but if an offer is consistent with and flows logically from a position of we're not going to increase wages past this 1%, then the union's failure to agree creates an impasse. And just the denial that impasse exists or some last minute movement under that case law is not enough to avoid impasse. Our position is that that's what we have in this case, because there is no dispute that despite 14 months of bargaining, the union never once offered a proposal that met both of the bottom lines that HRD had put forward on insurance and wages. And I just also want to bring this court's attention to other case law from this court, like TrueServe Corporation, where a finding of no impasse was not supported by substantial evidence in the record, where the parties bargained 8 times over 6 weeks. And at the end, the union's wage demand was twice as high as what the employer was willing to do. And the union failed to explain how it had any further room for movement on that issue. And that's exactly what we have here in this case. I do want to address quickly the exception to impasse. I do think the delays are quite significant in this case. Again, my colleague here did not have a case to illustrate where someone who had bargained for 14 months and the record reflects that affirmatively sought to repeatedly schedule bargaining was not at impasse or was not able to move forward with implementing a last final offer under an exception. So just as a very concrete example of the delay, on November 27, 2019, the union received its healthcare comparison, which took more than 2 months to procure. It did not communicate this to HRD. And the first dates that the union offered for bargaining in response to HRD's efforts to, again, move forward bargaining were in late January. And when January didn't work out, and we're not contesting, it was nobody's fault for the January dates not working out, the union refused to schedule anything in February and instead only offered dates in March. That all in conjunction with the long history of the case and these efforts to continuously put bargaining out further, that alone meets the exception to impasse, should be sufficient to qualify as an exception to impasse.
If you could wrap it up
Yes.
in the next couple seconds, please.
Thank you, Your Honor. For all the reasons that we've already discussed, either because there was an impasse or that an exception to impasse existed, we would ask that this court vacate the board's order. Thank you very much.
Thank you for your argument.
This honorable court has been adjourned until Monday, December 16th at 9:30 a.m.